And this is coming from landlords who, they're not property managers. Property managers know better. But this is coming from landlords. They think this is good enough. This is what a 3-day notice should look like, right? It's statutory. This is on our website. You can download it for free. You address it to the tenant, and then you have the middle where it says 3-day notice for non-payment of rent. You are hereby notified you're indebted to me in the sum of. You put the dollar amount there. You put the address, the apartment number, the city, the state, the zip, the county, and then you tell them you need to calculate your 3 days. And I'm going to show you how this is done. I'm going to pull up a calendar and show you how to calculate these days. And then you serve it on them, and you go to the bottom where it says certificate of service, who delivered the notice, at what time, how was it delivered to the tenant? Was it delivery, hand delivery, or did you post it in a conspicuous place on the premises, like on the door? And that is it for a 3-day notice. It's pretty simple, but a lot of people get it wrong. So here's what you do. Terminated for non-payment of rent. You have to serve a 3-day notice, okay? Make sure your clients know this. It can't be a text. It can't be an email. It has to be an actual physical notice. You also cannot use a PO box. Well, I shouldn't say cannot. You can, but then your 3-day notice becomes a 5-day notice. You're going to use a PO box, you need to make it 8 days, and you're losing time. If the tenant pays the full amount of rent, because your notice is going to say you are indebted to me in the sum of $3,000, right? If the tenant comes to you with $3,000 by law, you must accept it because you said pay or leave, and they decided to pay. You can't give early notices. So if you inherit a lease that you're not familiar with, look to the lease. Does the lease give a grace period? Like rent is going to be laid after the 5th, then you need to honor that. You serve it on the 1st, then it's a defective notice. Do not include late charges or utilities. It's rent only. There's a way around this. And the way around it is if your lease says late fees, utilities, and other charges are deemed additional rent. I look for that. And if that's not included, then I'm going to tell you charge rent only. Okay? So keep that in mind. Simple evictions, you're gonna just ask for the rent. If you're not sure, ask for rent only or give me a call. Do not include the day the notice was served when you're serving it. So if you serve the notice today, you cannot count today. Day 1 would be tomorrow, which is Thursday. Day 2 would be Friday. And then we skip weekends and holidays, and day 3 would be Monday. Avoid mailing, or you have to add 5 extra days, okay? And if it's a Section 8, you have to send a copy to the Housing Authority. I won't assume you all know what Section 8 is, but this is subsidized housing, where HUD will pay, if rent is $2,000 a month, HUD could pay $1,500, and the tenant is responsible for $500. So here's the calculation. Take a look at the day the notice is served on the 8th. Day 1, day 2, day 3 would be Friday. We skip weekends, always skip weekends and holidays. And then we can file the complaint on the 14th. So this is an almost perfect scenario. The only thing that could be better is if you served your notice on the 7th, and then by Friday, we're filing the eviction. Okay, but I wanted to demonstrate that you have to skip weekends or holidays. But here's a problem. What if you decided to use a PO box, or you decided to mail it? Instead of filing that eviction on the 14th, it's now going to be filed on the 17th. Look how much time this landlord is losing. Because after your 3-day ends, you have to add 5 consecutive days. And if you look in blue, you will see I added my day 4, 5, 6, 7, 8. And I know you might be thinking, but don't we have to skip weekends and holidays? When you're adding the extra days, You don't have to skip the weekends and holidays. The notice just cannot expire on a weekend. Okay, those are consecutive days. So the landlord is losing a lot of time. And here's how it could get worse. What if instead of the 8th, we serve this notice on the 9th? Now look what happens. Your day 3 previously was on Friday. Now your day 3 is on Monday. We're going to add the 5 consecutive days, day 4, 5, 6, 7, skip weekends because it cannot end on a weekend. And then the notice is going to expire on the 21st. This landlord has lost 2 whole weeks. This is without rent. And this is even before the eviction is filed. So it's super important to serve 3-day notices quickly and to do your calculations correctly. Because if this landlord came to me and it was done wrong, done incorrectly, they're going to have to serve it again. So keep that in mind. When you're serving 3-day notices, always consult your ledger. Don't try to wing it. Florida law states that a landlord can only demand actual rent, and I talked about this already, about how to deal with additional rent. If your lease deems it additional rent, then you can make late fees, return checks, utilities, repairs, and so on. If they are additional fees, you can make them additional rent. If that language is not there, you cannot include it. If a tenant, so here's what you need to know. Let me highlight a few things. If the tenant attempts to pay the rent in full, you must accept, right? What if the tenant attempts to pay you partial rent during that time period? You may accept it and repost a notice, or you can reject it. So here's how this works. Tenant owes $3,000. Tenant shows up and the tenant says, listen, I have $2,000 and I can get the rest to you in 7 days. That's a good amount of money. I would say, you call me up, I'll say, take it. Take it, and here's what you do. You serve another notice right there on the spot. You serve another 3-day notice for that $1,000. But if that same tenant showed up with only $500, you don't have to take it. It's your choice at this point. But what happens after the 3-day notice expires, but before you file the eviction? You can accept the money and repost a notice, or you can reject it altogether and just move on with your eviction. After filing the eviction, do not accept any money. That happens all the time. I see landlords who accept money and they'll say, and it could be as simple as a tenant deposited the money and the landlord doesn't even know the money is in the account. If it's more than a few days, the courts see that as acceptance. You just cannot accept any money during an eviction or the court will dismiss your case. The best way to handle that, if you come to me and you say, yeah, he gave me some money after the eviction, what do? We can write an agreement where you agree to accept the money, tenant gets to stay in the property. And that's an easy way. Stipulations, we call them joint stipulations for settlement. It's an easy way for a landlord to work things out with a tenant. Because at the end of the day, landlords want money. And if the tenant's going to work it out and the landlord's going to get paid, then everything works for both parties. So that is it in a nutshell for 3-day notices for non-payment of rent. Any questions so far on this? Negative. All right. So the next most common method or reason for eviction is terminating month-to-month tenancy. How do you form a month-to-month tenancy? Well, there are 2 ways. The first way is the handshake agreement. You know, 2 people meet, someone says, I got a place to live, you need a place to live, pay me $500 a month, and the person starts paying and they get the place to live and they do that a few months. That's a month-to-month agreement. It's not a written lease. The second method is a lease expires. It's a 12-month lease, the lease expires, month 13, landlord accepts rent, and he keeps accepting rent, but he never signs a new lease. You have a month-to-month tenancy at that point. So the first thing you have to do to terminate those is to serve a 30-day notice. It used to be only 15 days. 30 days is better. The advocates for tenant advocates wanted 60 days. My partner and I were on the legislative board that got some of these bills passed through in Tallahassee. And the compromise was 30 days. And I think it's a good deal because 15 days is really short to find a place to move. So 30 days. And the good defense, you have to make sure that the tenant cannot use this defense, that this is retaliation. Oh, I reported the landlord to code and then he decided to evict me. All right? You cannot retaliate against tenants. You can't evict them just because they reported you. Here's an example. There has never been a lease. It's a month-to-month tenancy. Rent is due on September 1st. Tenant pays rent, but is always late and does not get along with other residents. When can the landlord serve the notice and when does it expire? So here's the example. Rent is due on the 1st. You're going to give a 30-day notice. Some landlords think that it's just 30 days from now, right? I think today is the 15th. They think you just count 30 days and that the notice expires. No, here is the rule. Regardless of when rent is due, if you follow this rule, you will know how to calculate 30-day notices. Rent must always expire the day, let me back up. The notice must always expire the day before rent is due. And then you count backwards in time. And if you have 30 days, after you count backwards, you're good to go. If you have less than 30 days, you can't do it. So in this case, rent is due on the 1st of every month. The last day to serve this notice in this scenario is the 31st, right? Because rent is due the next day. Here's when the notice is going to expire. So the landlord serves the notice. He can serve it before, by the way. He can serve it 2 months in advance if he wants. But this is the last day. He served it on the 31st. Day 1 is the 1st, and day 30 is the 30th. You notice the lease, it expires a day before rent is due. So that's how you get your 30 days. So if you take today, for example, if you wanted to evict a tenant whose rent is due on the 1st, it would be too late. There are only 15 days left in May. So that notice would need to expire at the end of June. So that is how you calculate for terminating month-to-month tenancies. And you may have heard after COVID that there were all these rules and you had to give 60 days in some counties, and in some counties, it's 30, and in Miami Beach it was another. There were a lot of different rules, and the legislature has passed a law as of July of last year stating that local governments cannot make any law concerning landlord-tenant. It has to be done at the state level, because then it causes a lot of confusion. If you're in Miami, if you own property in Miami, Broward, and Martin County, you could have 3 different rules on how to terminate tenancies. So now it's 30 days statewide. Then you have a third. Did you have a question? Anyone? No. You have a third method, third most common method for terminating tenancies. And this is for lease violation. But this is the route you must try to stay away from if possible. The person comes to me and they say, hey, I want to evict this tenant. I'll ask, do they owe rent? And if the answer is yes, we're going to go that route. Yeah, but I don't want to evict them. I don't want the money from them. I said, that is the shortest route. I want to get rid of them because they have a dog. I said, listen, they're behind on rent. Let's go with the 3-day notice. Why? Because the burden of proof is on the landlord to prove that a tenant is violating the lease. And it's not easy to do. So you have to have clear evidence. In the other 2 methods I gave you, terminating month-to-month tenancies and 3-day notices, the burden is on the tenant to say, I paid the rent, or the landlord is retaliating. But here, the landlord has to prove breach of contract. So first thing you have to do is give a 7-day notice to cure. and the law says you need to give that 99.9% of the time. It's because most breaches are curable. An unwanted guest, unauthorized pet, that's curable. You give them a 7-day notice. Hey, I noticed that you have an unauthorized guest. I need them out in 7 days. Easy, that's a cure. When is a breach non-curable? Criminal activities, assault, battery. You can't really cure those things. So you can give a 7-day notice of termination. But I can count the number of times that I've served as a notice of termination. They are rare. It's best to always give a notice to cure. So here's a simple way to do it. If you're a property manager or a self-managing landlord, here's how you serve your 7-day notices to cure if you're going to do them yourself. You need to explain how they're violating the lease. So think of it logically. Here's how you're violating the lease. Cite a section of the lease they're violating and tell them what they need to do to cure it. So it's going to be as simple as, hey, you have an unauthorized guest. That satisfies number 1. Then it says, paragraph 6 of your lease states that you are the only person who can occupy the premises. And then you state, I need you to remove your unauthorized guest in 7 days. So it's that simple. It doesn't have to be fancy. If the tenant fails to cure within the 7-day period, then you can start an eviction. But you need to gather evidence first. Documentation, before and after. So if it's an unauthorized guest, or let's say it's an unauthorized pet, you can get pictures of the pet before and pictures after. You come back to check on the property after 7 days and the dog is still there, dog bowl is still there, then that person is still in violation and you can move forward. You can get police reports if it's noise disturbance. You can have witnesses available, affidavits. If the police were called to the property, you can have the police reports and police ready to testify if necessary. These are some pictures from some cases that we did where landlords said, no, there are no pets in the property, but clearly there were, and the judge did not like it. Oh no, this guy doesn't live there, but the landlord's address for this guy is the address where we're evicting from. But this occupant lived at that address. Unsanitary conditions, you can evict people for that. Here, these are, the statute says the tenant shall keep the property clean and sanitary. So if you look at the picture on the right, the one inside that's messy, but you look at the one on the right, that's a person who's obviously hoarding, and that's unsanitary. Here's another one, and you can serve 7-day notice to cure on these people, and then you can evict them. So those are your 3 main methods. There's one more that I didn't put in, and that's holdover tenancies. So leases naturally expire. All right, if you have a 1-year lease and it ends in May, the landlord doesn't have to remind you unless it's written in the lease. You're just expected to move out. But even if he reminds you and he says, listen, your lease expires at the end of May and I need you to move out, and you decide not to, you're now a holdover tenant and the landlord can move straight into eviction at that point. It doesn't need to give you any notices. What's the process like in Florida? So as I stated before, it's relatively short. Depending on the county, it could be 4 weeks uncontested. What is uncontested? It means that the tenant has not challenged the eviction. You file an eviction, they don't file an answer, they say nothing, they do nothing, the judge is going to give you a final judgment. If the tenant responds and says, hey, I have this money order that shows that I paid the rent, then it's now contested and you can add another 2 weeks. So if we're using an average of 4 to 6 weeks for an eviction, and then if the landlord is waiting for weeks before serving a 3-day notice, you can see how far behind the landlord can get. Sometimes when landlords come to us, they're already 3 months behind. They listen to stories first, and they try to give the tenant a chance, and that's fine. You know, run your business however you want to if you're running a landlord-tenant business. But just know that you're the one who's most likely left with a big bill. The tenant doesn't leave or doesn't pay as promised. So here are the steps. I'm going to break it down. Deliver your 3-day notice or your 30-day notice or your 7-day notice. You deliver them. You always deliver a notice. That's step number 1. When that notice expires, we file the eviction in county court. A process server will go out to the property and serve the tenant. If the tenant is not in the property at the time, the process server is authorized to post that summons on the door 6 hours later. So they leave, they come back 6 hours later, knock on the door again, then they can post it. Because sometimes tenants would avoid service. They could hide and then you would never serve. So the law allows you to post it. If the tenant does not respond, then we ask the clerk for a default, and then we submit a final judgment to the judge. The judge takes about 10 days to enter a final judgment, then send a writ of possession to the sheriff. The sheriff will post a 24-hour notice in a few days. Then he makes an appointment with the landlord to come out to the property and remove the tenant. That is how it's typically done if it is uncontested. Now, if it's contested, where the tenant files an answer, if you file this on your own without an attorney, which you're free to do as a landlord, if the property is in your name, you can file evictions on your own. And if the tenant doesn't answer, great. You saved yourself some money. But if the tenant answers and the property is in your name, you can continue. You can say, yeah, I know what I'm doing. I took Mr. Grant's class. I know how to do this. And you can do it. But if your property is an LLC or some kind of entity, you need an attorney. You cannot represent that entity at that point. If you are a property manager, you can also file evictions, but once the tenant answers, you can't go any further. You will need to get an attorney or have the landlord do it himself if it's not an entity. So here's what the judge could do once a tenant files an answer. The judge could order rent into the registry. So the court has an escrow system. And if the tenant says, yeah, I really don't have the money, but I could get it, the tenant's admitting that they owe the money. So the court can say, oh, you admitted that you owe $3,000. You need to deposit it into the court's registry by Friday, or I'm going to enter a final judgment. The judge could also order mediation. This typically happens if the tenant deposits the money. The judge will say, I need the parties to talk about it and try to settle first. The judge could order a hearing to determine rent. When does this happen? When the tenant says, the amount looks wrong, or here's my money order, I paid the landlord. Then the judge is going to say, well, something's wrong here. I need you all to come in so I can see how much money is really owed. Or the judge can do a final hearing. The judge can just say, you know what, I'm going to have a trial, everyone come in, and they're going to wrap the case up on that day. We have other options that we as attorneys use: motions to strike, motions to set cause for trial, and we also like to use stipulations. So most of our landlords, as I mentioned before, their goal isn't to have empty apartments. And if a tenant can work something out, we encourage it. We encourage our landlords work something out. You can get into a joint stipulation agreement where it's an agreement between the parties. So the tenant will say, yeah, I can pay you $2,000 now, and the other $1,000 I can pay every month. And if the landlord agrees to that, we write that up. $2,000 due upon execution, $500 due on May 30th, another $500 due on June 15th. And then the landlord should get the money that they expended, the filing fees, their court costs, their attorney's fees. You can also put that in installments. And that's one way of helping the tenant out. Another way is if the landlord wants the property back and the tenant says, listen, I really don't have the money. Can you give me until the 30th to move out? You can agree. You talk to me about that, and I would say, well, this case is going to take about 6 weeks. The judge is going to have to set it for a hearing, but they're promising you that they're going to move out on the 30th. It's a good gamble. So let's go for it. We would do an agreement. Tenant agrees to vacate the property on the 30th. And if the tenant fails to do that, the tenant's going to get evicted because it becomes a court order. The court signs it, the landlord signs it, and the tenant signs it, and it becomes a court order. So if on the 30th the tenant doesn't vacate, the next day the landlord can send in an affidavit saying tenant is still in the property, and the judge will enter a final judgment and order the sheriff of the property. So you're giving that person a chance, and you're protecting yourself at the same time, because if they don't leave or don't pay, then you just have to reopen the case, and you're going to win because they're the one in breach of the agreement. So we like to use those to create win-win situations. Let's talk a little bit about the writ of possession. This is where the sheriff comes out to the property. When is it necessary? I think the writ of possession is necessary at all times. Some landlords want to save the $90 or the $115. Miami's $115. So they want to save that money. They've spent all this money getting through the eviction, and then they don't want to spend $90. They'll say, I think the property is empty. I'll say, all right, do an occupancy check. I'm not sure. I looked through and I saw a few items in there, but they look old. Well, you're not sure. If you take possession of that property, you could be held liable. You need the sheriff to come out and remove that person from the property. Now, if the tenant tells you in writing, so I'll say, all right, there are a few things in there, text the tenant. And you say, hey, did you move out of the property? And the tenant said, yes. And you can throw out all the stuff that's left in there. That's great. They've just given you permission, and that it's in writing that they left. You can take possession without a writ of possession. But if it's not that clear, you should get the writ of possession, because I've seen bad things happen. I've seen landlords take possession only to find out that the tenant was out of the country. Tenant came back, all their stuff is thrown out. The judge is very upset about that. So, and I've seen a landlord, a property manager went in, and there was an old mattress, and the property manager threw it out, and the tenant came back and said there was $5,000 under that mattress, and the property manager stole it. Now, of course, the judge knew that the tenant was lying, but at the same time, the property manager had to hire us, pay us money, go to court, when they could have just for $90 gotten the sheriff to come out to the property and give them official possession. And the law says once the sheriff gives you possession, you can throw out anything, put it out on the curb. You're not liable at that point. Common mistakes to avoid. Yes, there were 2 tenants on the lease. One of them gave me the keys and put it in writing that they were gone and I could throw everything away. If it's 2 tenants, they both need to consent. But only junk was left in the property and the power was off. You don't know that. You don't know it was junk. Just because the power is off doesn't mean anything. Some people can live without power. The neighbor saw a U-Haul, the power was off when I checked, so I took possession. Tenant went silent on me and wouldn't respond to my emails, so I assumed they were gone. All right? Those are not good reasons. I just put this here for shock value. This is when you get possession of the property, you can put everything outside at a designated area. And this happened. Would a landlord be liable? Nope, you're not liable. The sheriff handed you possession officially, and whatever happened here, you're not liable. But if you took possession without the sheriff and then this happens, you could be held liable. Landlord also has a duty to maintain the premises. So we talked about tenants and tenants not paying and giving 30-day notices and so on. But landlords have a duty too, okay? So you see this picture of this bathroom. Landlords have a duty to maintain the premises. They have to abide by the housing and health codes, roofs, windows, doors, plumbing, screens, heating, extermination, smoke alarms, and there are exceptions for single-family homes and duplexes. With a single-family home, you can waive those responsibilities. So a tenant might say, I want to live here and I don't want you to bother me. I'll be responsible for everything. If there's a roof leak, I'll fix it myself. I'll fix windows. I'll do all those things. You put that in writing and the tenant is responsible. You cannot do that for apartments and condos. So only single family homes and duplexes. Common mistakes that landlords make. Not making repairs in a timely manner. All right. I mean, if you're a tenant, you're going to be pretty upset when a landlord does not make repairs timely. Not curing code violations, ignoring 7-day notices to cure from the tenant. And you didn't know that, did you? Tenants can serve a 7-day notice to cure on the landlord. And the landlord, so the tenant could say, hey, you need to fix this roof leak, or I'm going to withhold rent. Number one, you can withhold rent, or I'm going to vacate with no penalty. So those are two methods. Most people choose to withhold rent, and the law allows you to do that. You just have to serve your 7-day notice properly. So the tenant can serve, as I said, this is in the second bolded area here, vacate after 7 days or withhold rent. You also have something called constructive evictions. Constructive evictions are where the property is in such bad shape that the tenant really can't live there. And failure to repair the property makes it uninhabitable. A judge can order the tenant to not pay rent, or the judge can abate rent in proportion. So if it's a 2-bathroom, 2-bedroom, 2 baths, and 1 bathroom is uninhabitable, the judge can reduce rent, like take $600 off the rent until that bathroom is fixed. If it's a Section 8 property, HUD will do an inspection, they will fail the landlord, and they will not pay you. And they're not going to pay you in back rent either. And you're going to be without money, and the tenant's not going to pay you. So you need to always make sure you fix. Mold issues, go over it just briefly here. There's more to this, but I've boiled it down to just these essentials. Landlord has a duty to assess and remediate mold. All right. The landlord should make sure that it's a licensed professional that comes to the property. The landlord should tell the remediation specialist not to talk to the tenant or give any information. All communication should come from the landlord, and don't give copies to the tenant. You have no obligation to pay for a hotel room if the tenant needs to vacate the property, but you should reduce rent on per diem. So here's some best practices for the landlord who wants to be a good landlord. Have a system in place. Don't just wing it. Have a written system in place of how you're going to handle things. Do not ignore requests for repairs. Communicate and document your efforts to cure issues, because some tenants like to complain. They know the law very well. So they'll complain and then they won't allow the landlord to cure. And I see it all the time. Oh, I have this problem with my washer, and then the landlord makes an appointment, tenant doesn't show up, or the tenant doesn't let them in, or whatever is going on, but the tenant keeps complaining about that washer. So you need to document, call the tenant on this day, and or I sent a letter, I did all these things, and you need to document that. Because when it's time to evict them for non-payment, because they're going to withhold rent, you need to show the judge that you tried. Here's some examples. Does a landlord have a duty to maintain air conditioning? Yes, it's not a statutory duty like water and heating, which is statutory by law that cannot be waived. The air conditioning, if the property came with air conditioning, then you're obligated to repair it, just like you would for a refrigerator or a stove. In month 10 of the lease, a tenant complains about a broken screen on the same window that you fixed in month 2 of the lease. Do you have to repair it? The law says you have to repair screens once every 12 months during a lease. So if you already repaired it, you don't have to do it again. A tenant in a single family home has a broken window that you suspect was broken by the tenant's minor child. Do you have a duty to repair it? Well, yes. Yeah, unless it's waived, unless it's a single family home or a duplex, you have a duty to repair windows. You can figure out a way to charge the tenant later, maybe charge it to their security deposit, send them a bill, whatever you want to do, but you have a duty to fix it unless it's waived in the lease. If it's a single family home or a duplex and you have that language that says the tenant is responsible, then the tenant is responsible. But it's a catch-22 because it's your property. If the tenant doesn't have the money to fix that window, your property is going to get damaged. So those are not the things I would waive as a landlord. Roofs and windows. And I would advise you to fix those anyway and try to get the money from the tenant later. Section 8 evictions, they work just the same. All the things I explained to you, serving the notices, it works exactly the same, except you have to send notices, copies of the notices that you serve to the housing authority. If it's a non-payment issue, you can only demand the portion of rent that the tenant is responsible for, unless they were terminated from the Section 8 program. So if Section 8 is paying their $1,500 and the tenant isn't paying their $500, you can only ask for the $500. If you fail inspection and Section 8 abates rent, which means they're not paying you, you can only demand the tenant's portion also. But of course, you know, the tenant's going to say, hey, you failed inspection, so I'm going to withhold rent. So you're not going to win that. Security deposits, easy to deal with. If it's a good tenant, you're not keeping the security deposit, return it within 15 days. If you intend to keep the deposit because something was damaged, you must by law give a notice of intent to retain. So even if whoever is watching this right now, you know, I have lots of clients ask me about this. You know, a landlord didn't return their security deposit. Landlord has 30 days. They have to give you a written notice, their intent, and they have 30 days to return it. 30 days. On day 31, they forfeit the right to that deposit. They have to send it to you by certified mail. If you didn't leave a forwarding address, then they will send it to the last known address. And if you left a forwarding, then it will get to you. Tenant has 15 days to object in writing. So keep that in mind. Those are the rules for security deposits. So you have to send your notice of intent to retain the deposit. If the tenant responds, the landlord has 3 options. Tenant says, no, I don't agree, you should keep my deposit. You have 3 options. Return the deposit to the tenant or negotiate a partial. You can say, listen, I know you need the money, but you did break the cabinet door, but here's what I'm going to do. I'm going to give you a half of it. Usually people will agree. They'll recognize that they did something wrong and that you're also giving them some money back. And that typically works. Or you can just keep it. Just say, you know, whatever you want to the tenant. Screw you, I'm keeping it. And then over the next 5 years, you can expect possibly a lawsuit. They have 5 years in which to sue you for a return of that deposit. So just think about it. Ways to improve your return on investment. If you're a landlord, property manager, you're thinking about doing this, have a landlord-friendly lease, okay? The FAR bar one is easy to use. You all have access to it. It's easy to do one. It's great, but it's balanced, okay? If you're a landlord, you want a lease that puts you in the best position possible. Don't include grace periods because it just delays the amount of time it takes for you to file that eviction. Be diligent and consistent when you're posting your notices. As soon as rent is late, just have that in your process. You let your tenants know that, listen, not that I don't believe you, but I serve 3-day notices on the 5th. As soon as rent is late, 3-day notices are going to be on the 5th. And that's it. They know what to expect. Don't listen to stories for 2 weeks, okay? Get some kind of proof. Oh, I have a new job. They won't pay me for 2 weeks. You know, get some kind of letter or some kind of proof. If you're managing apartments, it can get pretty bad. Tenants talk to each other. So if you have a unit, 6 or more, or even 4, and you're giving one person preferential treatment, you know, this person is allowed to be late, they pay whenever they want, they talk to each other. The person who's paying on time is going to say, why should I pay on time when I know you don't hold everyone to the same standards? And I've had tenants who've gotten together to come up with ways, banding together to not pay the landlord, so you have to be very careful there. Tenant has the option to pay back rent and eviction fees if you use a stipulation like I explained before. That's one good way of not having empty units and working with tenants and protecting your bottom line. Last but not least, the changes. If you're seasoned real estate people or you know landlord-tenant law pretty well, this is what you need to know. This is the update. I mentioned before that right after COVID, during and after COVID, there were all these laws passed in different counties and municipalities. So as of July 2023, only the state can make and pass laws related to landlord-tenant. Here are the laws that have been nullified. So if you remember these, you can get them out of your head. Free up your brain for something else. The notice of termination of tenancy, where it said 15-day notices or 30 days or 60 days, that's been eliminated. Statewide, the state law is 30 days for termination of month-to-month tenancies. Fair notice of rent increase, where if you wanted to raise rent, you had to give a 60-day notice and you couldn't raise it more than 5% or something like that, that's eliminated. Okay, you can raise rent if you want. You don't have to give any 60-day notice or whatever. You can tell the tenant, hey, when your lease expires, I'm raising rent. That's it. Notice of late fees, you're required to give these notices. Every time you assess late fees, you have to send the tenants notices. This has been nullified by state law, and some counties required a tenant's bill of rights, and this has also been nullified by state law. And the last thing, which I didn't include here, was the squatters. So there's a new squatter law that's going to take effect in July. It hasn't taken effect yet, but I'll let you know what it's about. This is where you can call the police to remove squatters, okay? And you will need to do an affidavit showing that you're the owner. Send that to the sheriff. The sheriff will verify the information. The sheriff will come and remove the squatters. And there are consequences. If you lied, you can get fined, you can go to jail. If the tenants are lying and they have fake leases, it's now a crime to do that. So landlords in Florida are a little more protected from squatters at this point. And that's it. Remember, as I said, this is a 3-hour class. I've distilled it, and I hope you'll learn something from that. I know you did, right? Because no one fell asleep. And that's pretty much it. Back to the floor. I cede the floor to Jeffrey.
Amazing, man. Thank you so much for that. Drop some fires in the room for that, man. That was great. I was a note taker. I definitely took some notes. I hope everyone took some notes here. And with that being said, Conrad, I know that people have questions for you. So if you guys have any questions, you can either go ahead and unmute yourself, or you can raise your hand, or maybe you want him to clarify something. Maybe you want him to go back to something. So
I don't know how to raise my hand. I have a question though. how do you get, after the judgment, how do you get your money from the
Oh,
tenant? Me
mm,
being the landlord and you sue, the judgment is given.
all right. Yeah, good. That's a very good question. So there are two ways to sue a tenant for eviction. You can do account one, which is for possession, and account two, which is for money damages, right? We only do count one for possession. Why? Because you don't have to personally serve them. And over the years, we've realized that you're not going to get any money from them. So you might as well take the quicker route. So if the tenant still owes you money and you have some kind of a judgment, it will be kind of a paper judgment sitting there. But what I've realized that a lot of landlords do is they send it to collections. So instead of suing the person, trying to serve them, and then getting this paper judgment that you can't collect on, and the judgment can stay on their record for 20 years, they just send it to collections and the collections people pursue it. So that's one way of doing it. But if you do sue them and you do get a judgment against them for the $3,000, you can try some methods such as garnishing and so on. But if they can't keep a roof over their heads, chances are they can't afford to pay you your $3,000. So you can have that judgment, but one day things might turn around. We've seen it. We've been doing this long enough where we'll see a person buying a property, and guess what? Their realtor reaches out to us or the title company, and they'll say, I have this person, and you have a judgment from 7 years ago, and they're trying to buy a property, and we need to know what we can do. You know, so it's worth it sometimes, depending on the.
But you said it only stays for 20 years?
Yeah, 20 years. Yeah. It's a long time, I think.
I
Hold on. Before you go, Conrad, turn your screen off so we can see you.
Thank you.
Me? Oh, no. Go ahead.
Turn your share screen off. Your slide.
Oh, yeah. Sorry. Stop sharing. All right. Wow, I'm in the dark here. I didn't realize it got dark. Can you see me?
we see you well.
Okay, good. So I don't have to go
Yeah,
turn on the.
When you do, I've just never gotten my money back, so I think you're right. The
Mhm.
other way it's quicker, but can their pay be garnished or their bank accounts be garnished? Or is it just that the judgment just sits on their public records?
Good question. So garnishment law, it depends on if the person has money or not, head of household. So there's some complicated things to it. But typically, you're not going to qualify to garnish that person. You know, if you're evicting a person for non-payment, usually they don't have any money. And so that you might not be granted garnishment. Now, if you evicted someone from Brickell and they were just trying to get one over on you and they have money, then that's a person you can collect from. But the vast majority of people who get evicted for non-payment, you're not going to be able to garnish their bank accounts or garnish wages. The judge is not going to grant, because they're usually indigent. Anyone else? But you could certainly try.
Hello, thank you for this. This is very insightful. So I am in Texas, and I was wondering, do you have a referral for a Texas law firm that you would recommend?
I would have to look because years ago I did work with some property managers, a company that started here in Florida, buying up a lot of properties, and they expanded over into Texas. And then from time to time, we would have to collaborate with their Texas attorney. So that's something I'll have to look into. So you just send me an email when you're done here, and it's Conrad@kellygrantlaw.com.
Perfect. And then the other thing, you did mention that the tenant has 5 years to sue the landlord for the security deposit.
Yeah.
When let's say the landlord does not do the repairs or anything like that, can they still come back and do anything? And is it even worth it at the end of the day?
If, for the tenant to,
Tenants, yes. So the landlord needs to make sure he does his repairs.
yeah,
Let's say there's a history of this landlord not taking care of repairs. That's why he's losing his tenants.
yeah.
So-
Yeah, the security deposit was it's kind of so yeah, I see what you're saying. So the landlord says, I'm keeping your security deposit. And then the tenant says, well, you didn't make all these repairs, so you're not, I don't want you to keep my deposit, something like that. Yeah, the tenant can do that, but the tenant needs to bring the lawsuit and the tenant needs to prove it. And the tenant needs to then bring in all the things that the landlord didn't do and that it was the landlord's responsibility. Why the cabinet door came off because there was a leak and the leak affected the door and the landlord never fixed the roof. So those are the types of arguments that the tenant could make in getting their security deposit back. That's the landlord's fault.
Got it. Do you represent both tenants and landlords?
Landlords only, as of years ago, because conflicts. You know, once you start running into a tenant that you evicted some time ago, so we just do landlords.
Okay. So I'll go ahead and I'll email you and then yeah, I'll email you.
Sure, thank you.
Thank you so much.
Anyone else? And you can always email me. If you can't think of anything now or you don't want to say it, I will answer and call if I need to. Big deal.
I guess the information was too good. We're probably going to get this question 30 times tomorrow. Will the presentation be sent out, Conrad?
It can be if you recorded it. I didn't because it's not my Zoom. Did you?
Beautiful. Beautiful. Yes, we did. Yes, we did.
Okay, great. Yeah, so yes, you are authorized to send it out. Okay. Not to sell it though. Well, if you do, just, break me off.
I love it. Anyone else? Any questions from anyone else? Leslie, looks like you want to say something. Go ahead and unmute yourself. And it's 8:08, folks.
Can't hear.
We can't hear you, Leslie. Maybe it's the audio on your computer.
She said no in the chat box.
Got it.
Oh, okay, got it. All right.
So, Conrad, do you
Well,
want to tell the people what else you guys do in addition to
yes,
tenant
absolutely.
landlord
Thank you.
representation?
Yeah, thank you for reminding me. Yeah, so we are a full service real estate law firm, which means we handle landlord-tenant law, title and closings, homeowners association, condo associations, wills, estates planning, and general litigation for real estate. So quiet title claims, those kinds of things we have. And yeah, any real estate matters, you can come to us. Short and sweet, you'll remember it.
I love it. My personal title company, Conrad, handles a lot of my personal stuff.
What I've learned to do over the years is lawyers talk a lot, and I've learned to just be brief and deliver information, just that you need. But yeah, we have the tendency to talk. Like you ask me a question like that, and it could be 20 minutes of talking. So that's it.
All right, ladies and gentlemen, it's 8:09. Just want to remind you guys, tomorrow at 9 a.m. Eastern Standard Time, you want to definitely make sure you're plugged in to our session as we go over. Claudia's going to spend the first 5, 10, 15 minutes on how to accept an offer using a Google form. So if you're not a part of our organization here at EXP Realty and you want to learn how to handle multiple offers, as we're seeing those are coming out quite a lot now, you want to join us, at our morning huddle, which takes place every Monday through Friday at 9 a.m. Eastern Standard Time. Next week, we'll have Sonia Hickman speaking about foreclosures, how to go into the courthouse on the internet and see who has an auction date, a sell date, and how to make the phone calls, how to win over the sellers, and how to get that maybe into a traditional sell or possibly into a short sell. So 7 p.m. Eastern Standard Time. And I don't know if you have anything else for the people, Claudiane. Is that a no? I guess not, ladies and gentlemen. We'll catch you guys back here tomorrow for our training at 9 a.m. Take care. Conrad, thank you so much.
Yeah, thanks for having me. Appreciate it. Thank you.
Most definitely. Bye-bye.